House Committee on the Judiciary will come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time. Before we begin, I want to thank the members and the witnesses for their patience in delaying the start of the hearing. We welcome everyone to this morning's hearing on the Texas abortion ban and its devastating impact on communities and families. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I'd also remind members that guidance from the Office of Attending Physician states that face coverings are required in all meetings and enclosed spaces, such as the committee hearings, except when you are recognized to speak. I will now recognize myself for an opening statement. 65 days. That is how long women in Texas have been effectively stripped of their constitutional right to abortion. Earlier this year, Texas enacted Senate Bill 8, or SB 8, which bans abortions after 6 weeks of pregnancy, before many people even know they're pregnant, thereby effectively blocking abortion access in the state entirely. But although the law is clearly unconstitutional, its unique structure, which relies solely on a private enforcement or really bounty system, has thus far allowed it to evade judicial review on the merits. SB 8 offers up a bounty, a minimum of $10,000 in legal fees, to those who successfully bring a suit under the law's private cause of action provision. This provision permits any individual to sue not only abortion providers, but anyone who, quote, aids or abets a violation of the abortion ban, a term so broad that it could encompass practically any action, from driving a patient to a clinic to merely offering personal advice. This law created a perfect storm in Texas, which already had some of the most restrictive abortion laws in the country because of the way it was written and because of its enforcement method. The Supreme Court had two opportunities to stop the law from taking effect during pending legal challenges, and twice it failed to do so. As a result, communities and families in Texas have been devastated, and the ban has had ripple effects in states around the region and the country. There is no question that SB 8 is blatantly unconstitutional, and that the Texas legislature intentionally ignored decades of legal precedent in enacting the law. But to anyone who's been paying attention, this law did not appear out of nowhere. Rather, it is the result of a decades-long, well-funded campaign by anti-abortion activists to steadily chip away at the right to abortion. These efforts have culminated in SB 8, and they have had one goal: to challenge and eventually to overturn the constitutionally protected right to abortion. Nearly 50 years ago, the Supreme Court recognized that right in Roe v. Wade. The Supreme Court has repeatedly upheld this critical constitutional right against legal challenge. Generations of Americans have come to rely upon the right to abortion to make the deeply personal decision about whether or when to have children. As the Supreme Court observed nearly 30 years ago when it reaffirmed the right to abortion in Planned Parenthood versus Casey, the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. Access to safe, legal, and affordable abortion allows people to make choices about their own lives: when to start a new job, when to go back to school, and eventually when to start or grow a family. When states chip away at, or in the case of Texas, nearly ban abortion access, they're not just controlling women's bodies, they are controlling their lives. And that impact falls most directly on communities of color, low-income women, and vulnerable populations. Excuse me. This hearing occurs just days after the Supreme Court heard oral arguments in Whole Women's Health versus Jackson and United States versus Texas, legal challenges to SB 8 brought by abortion care providers and the Department of Justice, respectively. At the heart of these cases is the question of whether a state can effectively nullify the Constitution within its borders. SB 8 is designed to thwart a court's authority to review and potentially block a state law that prohibits the exercise of a constitutional right before it takes effect by delegating to private parties the authority to enforce the law. SB 8's bounty system, which is just as troubling as the 6-week ban it is meant to enforce, is a deliberate and disturbing effort by the Texas legislature to evade judicial scrutiny long enough for a clearly unconstitutional law to take effect. And it worked. SB 8's bounty system should be concerning to anyone who holds dear their constitutional rights. As Justice Kavanaugh, likely no fan of abortion rights, suggested during oral arguments on Monday, SB 8 could set a troubling precedent and a model for states to undermine not only abortion rights, but any constitutional right that a state legislature may disfavor, whether it be the right to free speech, the right to religious liberty, or the right to bear arms. In addition, this perverse bounty system is designed to have a chilling effect on the ability of people to access abortion. Pregnant people in Texas may now be reluctant to confide in once trusted neighbors, coworkers, or friends, or to seek help from organizations and advocates if they have questions. Providers have expressed confusion and concern about how to advise their patients and where to seek care for pregnancy complications. The system is built to create fear, anxiety, and isolation for women and for providers in the state, and in many ways it has succeeded. But SB 8 has not diminished the need for abortion in Texas or anywhere else in the country. People in Texas, particularly those in communities of color and low-income communities, already faced immense hurdles in accessing abortion. In the last 20 years, Texas has passed some of the most extreme anti-abortion laws in the country. Even before SB 8, women were required to make multiple appointments, receive medically unnecessary sonograms, and listen to false and misleading anti-abortion propaganda. And because Texas bars any insurance, public or private, from covering abortion care, women must pay for this entire process out of their own pockets, which can cost anywhere from $300 to $1,200. All of this assumes that they can even reach an abortion provider when more than 900,000 Texans of reproductive age live more than 150 miles from an abortion provider. None of these rules and restrictions are science-based or medically necessary. They are designed to stop women from accessing abortion and to control women's lives, plain and simple. And Texas is not alone in enacting these restrictions. States around the country have passed similar laws, and many now stand poised to pass copycat SB 8 laws as well. These restrictions and laws make abortion almost completely inaccessible, and they hit communities of color and low-income families the hardest. People who work hourly jobs, already have children, or live miles away from an abortion provider face impossible decisions and often insurmountable obstacles in finding the time, money, and support to access care. All of these steps and decisions take time, pushing people later into their pregnancies and making care more difficult to access and more expensive. And SB 8 has only exacerbated this situation. The need for abortion has not disappeared in Texas under SB 8, even as the number of abortions provided in Texas has dropped by an estimated 50%. People are now seeking care out of state, traveling hundreds more miles, taking more days off of work, and spending much more money. All of this to get the care that they need, the care that they have a constitutional right to access, the care that is integral to their dignity to live their about SB 8 and abortion rights is not a theoretical one. As we will hear today, SB 8 and similar abortion restrictions are impacting real women and real families every day. I will stand with these women and with their providers. I will not stop fighting to protect the right to abortion and the right of every American to live their lives with dignity. I thank our witnesses for being here, and I look forward to their testimony. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, life is precious. Every single life is precious and worthy of protection. And that fundamental principle is what the Texas law is about. It's what the pro-life movement is about. But that's not what Democrats are about in Congress. Democrats are now trying to abandon the Hyde Amendment. Language that's been in our law, been in every appropriations measure for the last 45 years, which says that federal tax money, the American people's tax money, will will not be used to take the life of an unborn child. Even with the Hyde Amendment in place, over $500 million in taxpayer funding is flowing to Planned Parenthood annually. And now, if the Hyde Amendment is actually repealed, as the Democrats seek to do, Planned Parenthood, which does over 350,000 abortions per year, will stand to get even more taxpayer money. For decades, Democrats respected that those who oppose abortion should not have their tax dollars used to fund it. Now they don't. Even President Biden changed his position. He used to be for the Hyde Amendment language. Now he's not. That's how radical the Democrats' position has become on unborn children. Republicans have numerous bills that would protect the unborn, and it is our great hope that someday our colleagues on the other side of the aisle would considering moving those pieces of legislation. But let's be honest. Democrats aren't here today to have an honest debate about the sanctity of life or the role of government in protecting unborn children. Instead, they're here to play politics with our institutions and advance a radical leftist agenda. Right now, there are three life cases before the Supreme Court. And this very week, the same week that the chairman chose to convene this hearing, the court held oral arguments on 2 of those cases. Let's be clear. The Democrats have convened this hearing as a way to pressure the Supreme Court to try to intimidate the Supreme Court. It's a playbook Democrats used when the court was considering the census last Congress, sensationalize a legal question to delegitimize the court's role in interpreting the law. Today, their focus is on this pro-life law from the state of Texas. Last year, while the court heard oral arguments in the case regarding a Louisiana pro-life law, Senator Schumer stood in front of the Supreme Court and said this: I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these awful decisions. If that's not threatening, that's not trying to intimidate, I don't know what is. He did that in front of the Supreme Court that day. And in April, Chairman Nadler and other Democrat members of this committee made good on Senator Schumer's threat. They introduced legislation that would add justices to the Supreme Court. 4 associate justices, not 1, not 2, not 3, but 4. And why might they want 4 new justices? Because 4 new justices appointed by President Biden is the golden number for getting to a liberal majority on the court. Even President Biden's bipartisan commission criticized this issue in their preliminary report last month. They wrote, court expansion is likely to undermine rather than enhance the Supreme Court's legitimacy and its role in the constitutional system. And there are significant reasons to be skeptical that expansion would serve Democrat values, close quote. But that didn't deter congressional Democrats. After the release of the commission's draft report, the chairman of this committee and other Democrats promptly issued a statement condemning its finding, deriding President Trump, and doubling down on their plan. Quote, we must pass legislation to expand the Supreme Court. And just yesterday, Congressman Jeffries doubled down on Democrats' attack on the court, tweeting, the right-wing majority on the Supreme Court is completely illegitimate. That statement doesn't make sense. I mean, I think Mr. Gorsuch, Mr. Kavanaugh, Justice Coney Barrett, I think they were all nominated by the president, confirmed by the Senate. I think they're as legitimate as you can get under our constitutional system. But somehow the Democrats view that as illegitimate simply because they're pro-life. Just so we are clear, the chairman of the House Judiciary Committee, the committee charged by the American people with overseeing the judiciary and the federal justice system in our country, has introduced legislation to upset the balance of the Supreme Court, all for political ends. This is just one branch of the government that Democrats don't control, and they can't stand it. The American people, I think, see through this all. The Texas law, again, is focused on the sanctity of life and protecting those who can't protect themselves. That's what the pro-life movement's about. Life is precious, and let's protect those who can't protect themselves. Democrats in Congress are focusing on pressuring the court, intimidating the court, and packing the court. And the American people see it for what it is. I want to thank our witnesses for being here, especially Ms. Foster, and for her work with Americans United for Life. Mr. Chairman, I yield back.
Without objection, thank you, Mr. Jordan. Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses. Dr. Ghazala Moyedi is a board-certified OBGYN and complex family planning specialist in Texas and Oklahoma. She's also the founder and chief medical officer of Pegasus Health Justice Center and serves as a board member of Physicians for Reproductive Health. Dr. Moyedi received her undergraduate degree from the University of Texas at Austin and completed her medical training at Texas College of Osteopathic Medicine in Fort Worth. She trained as an OBGYN resident at Texas Tech Health Sciences Center in El Paso and completed her fellowship training in complex family planning at the University of Hawaii, where she also received her Master of Public Health degree in Health Policy and Management. Kiara Bridges is professor of law at the University of California, Berkeley School of Law. She previously taught at Boston University, Harvard Law School, Stanford Law School, and Yale Law School, good trinity, and served as the Center for Reproductive Rights Fellow at Columbia Law School. She received her BA from Spelman College and earned both a JD and a PhD in anthropology from Columbia University. Catherine Glenn Foster is president and CEO of Americans United for Life, as well as a senior fellow in legal policy at the Charlotte Lozier Institute and a fellow with the James Wilson Institute on Natural Rights and the American Founding. Previously, she spent 7 years as litigation counsel with Alliance Defending Freedom. She then founded and managed a law practice and led Euthanasia Prevention Coalition USA as executive director. Ms. Foster earned her BA from Berry College, a master's degree in French from the University of South Florida, and a JD from Georgetown University Law Center. Stephanie Lorraine Pinheiro is co-executive director of the Florida Access Network, an abortion fund dedicated to challenging abortion stigma and dismantling barriers to abortion in Florida through financial and logistical support. She received her BA from the University of North Florida and a Master's of Social Work from the University of Central Florida. We welcome all of our distinguished witnesses and we thank them for participating today. I will begin by swearing in our witnesses. I ask that our witnesses in person please rise and raise your right hand. I ask that our remote witnesses please turn on their audio and make sure I can see your face and your raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief? So help you God. Let the record show that the witnesses have answered in the affirmative. Thank you, and be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For our witnesses appearing virtually, there is a timer on your screen to help you keep track of time. Dr. Moyedi, you may begin.
Good morning, Chairman Nadler, Ranking Member Jordan, and distinguished members of the committee. My name is Dr. Ghazaleh Moyedi, and I use she, her pronouns. I'm a board-certified OBGYN, the child of Iranian immigrants, a mom, a Texan, and a proud abortion provider. I serve on the boards of Physicians for Reproductive Health and Texas Equal Access Fund. For over 60 days, abortion care has been nearly inaccessible in my home state of Texas due to Senate Bill 8. Texans have been waiting for the courts, for Congress, for anyone to intervene and halt this unconstitutional abortion ban. I'm here today because we are still waiting. As dangerous and as cruel as this law is, accessing life-saving abortion care has always been a challenge in Texas, even before SB 8. Last month, when I testified to the House Oversight Committee on this very issue, I asked the committee to spend a few minutes thinking about what it's like to be a person needing abortion care in Texas or in this country. To consider Marie, a 35-year-old American citizen, 18 weeks pregnant, working a minimum wage job, living in Dallas and seeking abortion care in August, prior to SB 8 even being enacted. She, like most people who have abortions, is already a parent and resolute in her decision to end her pregnancy. And although Marie is confident and informed about her decision, simply because she lives in Texas, Marie is forced to endure multiple harmful restrictions when accessing abortion care. Marie is forced to seek out this care at only one of 2 specialty clinics in Dallas, not from her regular healthcare provider, because Texas has a law that requires abortion care after 16 weeks to be provided in an ASC, an ambulatory surgical center, a requirement that has been proven to be medically unnecessary and does nothing to improve the quality or safety of care. If Marie is able to make her appointment at one of our 2 ASCs in Dallas, she cannot have her abortion on the day of her appointment. Marie is forced by Texas law to make an appointment with a physician in advance of her procedure. As her physician, I am then compelled by the state to force Marie into a medically unnecessary ultrasound. I'm compelled by the state to force Marie to look at and listen to the ultrasound. I'm compelled by the state to force Marie to hear a description of the ultrasound. I'm compelled by the state to force Marie to receive medically inaccurate state-mandated scripts. And after all of this, I'm still compelled by the state to force Marie to wait at least 24 hours to receive her desired health care. Now, if Marie were 16 instead of 35, her abortion care would be even further delayed by the need for parental consent or judicial bypass. If Marie were undocumented and living in El Paso instead of Dallas, she would be completely denied access to abortion, because even before SB 8, the lack of abortion providers and the internal border checkpoints within Texas and New Mexico prevent Marie from accessing the next closest clinic. Now that the committee has heard how bad it was in Texas even before SB 8, I want to bring our story of Marie to today, right now. Today, Marie cannot get her abortion in Dallas. And because of the influx of Texas patients, the next closest clinic in Oklahoma City, where I also provide care, has a weeks-long waiting list for an appointment. I should not be forced to travel hours and hours away from my home to care for patients, for my neighbors who traveled hours and hours to see me. By the time Marie is able to schedule an appointment in Oklahoma, she will be 22 weeks pregnant and unable to get her care because of Oklahoma's medically unnecessary abortion restrictions. So now we're moving in concentric circles, further and further away from her home, further and further away from hope. An abortion ban in Texas creates a ripple effect of injustice impacting all of us. The influx of Texas patients is straining our neighboring states, pushing Oklahomans who need abortion care out of their communities to other states like Arkansas and Kansas. This is what SB 8 intends to do: deny people both in and out of Texas the ability to have abortions. Today, abortion care is almost completely stopped in our state, and the health and safety of all pregnant people in Texas is in jeopardy. We know chronic conditions can worsen in pregnancy, but not worsen enough to warrant an exception under this law. OBGYNs and other prenatal healthcare providers are confused about how to comply and care for their patients. Right now, today, physicians and hospitals in Texas are delaying life-saving care for critically ill pregnant people because their pregnancies still have fetal cardiac activity. As a physician, I know firsthand that abortion saves lives. For the thousands of people I've cared for, abortion is a blessing. Abortion is an act of love. Abortion is freedom. I want to end by imploring this committee to help our communities right now. We need federal protection of abortion care. And most of all, we need you to not forget about us, people of Texas and in other heavily restricted states, and our families and our communities. Thank you for hearing me today and holding this important hearing.
Thank you for your testimony. Professor Bridges, you are recognized.
Chairman Nadler, Ranking Member Jordan, and members of the House Committee on the Judiciary, thank you for the opportunity to testify before you today. My name is Kiara Bridges, and I'm a professor of law at the University of California, Berkeley School of Law, where I teach criminal law, family law, and reproductive rights and justice. I also serve as the faculty director of the Berkeley Center on Reproductive Rights and Justice. I'm here today to explain how abortion restrictions and bans, like Texas Senate Bill 8, disproportionately impact pregnant people of color, especially Black women. For decades, the Supreme Court has reaffirmed the central holding of Roe v. Wade. The court has affirmed that a person has a, quote, right to choose to have an abortion before viability and to obtain it without undue interference from the state, end quote. The court in Planned Parenthood versus Casey made clear that a, quote, woman's right to terminate her pregnancy before viability is the most central principle of Roe. It is a rule of law and a component of liberty we cannot renounce, end quote. Texas Senate Bill 8, which bans abortion after 6 weeks of pregnancy, violates the central principle of Roe. The law constitutes a near total ban on abortion, banning abortion far before viability and before many people even know they are pregnant. Consequently, SB 8 is unconstitutional. Nevertheless, SB 8 is currently in effect, that has been harming Texans in need of abortion care for over 2 months. And this is solely because the law leaves enforcement of its prohibition on abortion to private citizens instead of state actors, a feature of the law that its architects hoped would permit the law to evade judicial review. The United States Supreme Court cited these, quote, complex and novel antecedent procedural questions, end quote, as a reason for not enjoining the law. It is important to reiterate that the sole reason that SB 8 contains these procedural questions is that its authors wanted to give receptive federal courts the opportunity to leave the law in place. The Fifth Circuit and the Supreme Court took advantage of the opportunity that SB 8's authors gave them. The Fifth Circuit and the Supreme Court left the law in place. In the words of Justice Sotomayor, the state's gambit has worked. The law is in effect. For 2 months, abortion providers in Texas have been unable to provide care to scores of patients who desperately need it. Because Texans seeking to exercise their constitutional right to an abortion must now travel outside of the state to do so, the burdens imposed by SB 8 are tremendous, but the greatest harms have fallen and will continue to fall on the most marginalized people in Texas. Indeed, for the poorest people in Texas, these burdens are insurmountable. Crucially, because there is a close relationship between socioeconomic status and race, with Black people disproportionately living in poverty, burdens to poor people constitute burdens to Black people. The result is that disproportionate numbers of Black people will be among those who are coerced to continue pregnancies and have children against their will, to seek unsafe methods of abortion, or to risk exposure to criminal prosecution for attempting to self-manage abortion. Further, Black people receive abortion care at higher rates than their counterparts of other races. This is true in large part because Black people experience unintended pregnancies at higher rates than their counterparts of other races. Because Black people rely on abortion care more frequently than their non-Black counterparts, barriers to abortion, like SB 8, inflict greater harms on Black people than other races. Essentially, abortion restrictions do not have race-neutral effects. Feminists of color have long recognized the importance of ensuring that Black women and other Black people who can become pregnant are able to decide whether or not they will become parents. They have understood that there are forces that would coerce Black people into parenthood, like the forces that wrongly assert that abortion is Black genocide. They have also understood that there are forces that would deny Black people parenthood, like the forces that subjected tens of thousands of Black women to forced sterilization from the 1950s to the 1980s and beyond. Because feminists of color have realized that controlling Black people's reproduction has been a tool of racial oppression, they have identified Black people's ability to control their own reproduction as a tool for racial justice. Because the ability to terminate a pregnancy enables Black people to control their reproduction, feminists of color like myself consider abortion access to be essential to racial justice. Thus, SB 8 and other regulations that make abortion inaccessible are tools of racial subordination. Thank you.
Thank you. Ms. Foster, you are recognized.
Chair Nadler, Ranking Member Jordan, and members of the committee. I speak today on behalf of the constitutional and human right to life. I speak today on behalf of Texas and every community's right to protect our most vulnerable brothers and sisters, white, Black, Indigenous, and all people, from extermination. Let me tell you what the others here on today's panel won't. It's not our many degrees, our master's degrees, our Juris Doctorates, our medical degrees that distinguish us. These are all fine accomplishments, but none of them ultimately matter. What matters is what we share, our common humanity. And what is at stake is the same, our humanity. I have committed my life to advocating for America's common interest in life, and I'm committed to opposing the special interests that tragically advance killing as a public policy solution. If you asked most Americans on the street and told them that very serious people were convening hearings to call for more abortions to take place, they'd rightly be speechless. Yet that is what is happening here today, We're hearing incredible stories, testimony, pleas, marketing, really, for Texas, for America to embrace more abortions. What's true about abortion is this. 1, abortion is the violent tearing apart of helpless children, limb from limb. 2, abortion is the wounding and scarring of women and families for the benefit of multi-billion-dollar financial interests. 3, abortion is a cancer upon America. Abortion must end. I keep hearing the word devastating today. It's in the name of today's hearing, and pro-abortion activists are repeating it ad nauseum. Devastating. You know what's devastating? Cancer. Natural disasters. 62 million dead babies. That is what is devastating. 62 million dead babies killed in history's first for-profit, corporate-sponsored genocide. It's time for us to move on. As a constitutional attorney, I implore the Supreme Court and every federal and state lawmaker to act to restore the human right to life. We're hearing a lot about Texas, but all of this got its start because 7 men on the U.S. Supreme Court decided to do a terrible thing, to use Roe to nullify the Democratic consensus against abortion and impose abortion violence upon our people. The American people have never accepted the injustice of abortion culture. Americans United for Life advocates for the human right to life in culture, law, and policy. We've been fighting since 1971, from the beginning of the abortion wars, for those who govern in our executive, congressional, and judicial branches to simply do their jobs and to protect human life. There is nothing more alien to America's constitutional way of life than the toleration of abortion and its imposition on women who deserve better choices. Since Texas Heartbeat Act went into effect earlier this year, there are now literally thousands of human persons alive and thousands of mothers, fathers, families, and communities who will have the joyful chance at building a life together. A world with fewer abortions is a good world. A future with more Americans is a good future. And families and communities who are offered hope rather than sorrow are powerful witnesses to the importance of laws that serve justice and the good of all persons. I am here to remind you all of a truth that you already know. A world with fewer abortions is a good world, a better world. In a few years, the children who are alive today, thanks to Texas Heartbeat Act, will be old enough to understand that you think that it is devastating that they are alive. And their parents can hear you now, by the way. I celebrate them, and I celebrate every heartbeat protected and every life saved. We should be asking ourselves how we can support mothers and fathers from the moment of conception, as Texas does in every city and in every county through pregnancy resource centers and alternatives. And we should be asking how America can transcend the abortion debate, how America can enact and embrace robust national family policies that support the growth and the thriving of every life, every family, every community. We all have something priceless to contribute, but we must first be allowed to live. We can restore America's greatness by choosing to live joyfully together. We must offer one another our best choices rather than our worst, and then we can embrace what comes when abortion is no more, a lifetime of joyful possibilities. Thank you.
Thank you. Ms. Pinheiro, you are recognized.
Good afternoon, members of the committee. Thank you for the generous invitation to speak to you about the state of abortion access in Florida. My name is Stephanie Lorraine Pinheiro, and I work as the co-executive director of the Abortion Fund Florida Access Network. I'm a storyteller with We Testify, a Puerto Rican poderosa, a survivor of sexual assault, a jeva combativa, a bisexual woman who has had 2 abortions, and as a social worker with a master's degree from the University of Central
Thank you,
Florida.
Mr. Chairman.
Yes? Oh. I'm sorry, Mr. Pena.
Okay, am I on now? Oh.
Yeah. Clerk will restart the clock, and Ms. Pinheiro may start again.
Thank you. Good afternoon, members of the committee. Thank you for the generous invitation to speak to you about the state of abortion access in Florida. My name is Stephanie Lorraine Pinheiro, and I work as a co-executive director of the Abortion Fund, the Florida Access Network. I'm a storyteller with We Testify, a Puerto Rican poderosa, a survivor of sexual assault, a jeva combativa, a bisexual woman who has had 2 abortions, and a social worker with a master's degree from the University of Central Florida. As proud as I am to testify today, I am dismayed that I'm here to explain why we must continue to defend our constitutionally protected right to abortion. As a result of the Supreme Court's inaction, SBA was allowed to go into effect, adding yet another burden for people who want abortions. This emboldens states like my home state of Florida, who wasted no time in introducing an almost identical 6-week ban. I am worried about our future and what it means for people who need abortions today, tomorrow, and for years to come. I know what it is like to want an abortion, only to be tripped up by medically unnecessary restrictions and financial barriers. When I was a teenager, I became pregnant twice, once as a result of a rape, and again during a relationship when I was 17. Both times, I knew I wanted an abortion. After my rape, I felt ashamed and I blamed myself. I know now that being raped was not my fault, and wanting an abortion is nothing to be ashamed of, regardless of how someone becomes pregnant. Before my second abortion, when I was 16, my Catholic pediatrician refused to prescribe me birth control against my request. A year later, when my then boyfriend tried to purchase Plan B, the pharmacist refused to sell it. After I was denied Plan B, I spent weeks waiting for my period and searching the internet for clues about how I could self-manage my own abortion. I was afraid of violence escalating in my already unsteady home and about what could happen if I told my very strict parents that I needed another abortion. Like 72 million Americans, my family was enrolled in Medicaid. But because of the Hyde Amendment, my abortions were not eligible for coverage. When I had my abortions, I was a high school student, working as a waitress and helping my family during the recession, earning $2.17 an hour as my base pay, which is still the federal minimum wage for tipped restaurant workers. I had to pick up extra shifts just to afford the $450 for my appointment. I shouldn't have been forced to choose between supporting my family and paying for my abortion. Because Florida has a parental involvement law, I had to skip class to go to court and ask a judge, a complete stranger, for permission to end my pregnancy through a process called judicial bypass. With the help of my lawyer, I presented myself in a 5-page essay as mature enough not to parent a child when I didn't want to. Between the appointments with my attorney, the whole ordeal took several weeks and delayed my abortion even more. A decade after my experience, I co-authored a groundbreaking report with If When How, Lawyering for Reproductive Justice, which analyzed whether Florida courts could offer clear and unbiased information about the judicial bypass process. We found that over half of Florida's 67 counties could offer little or no information about the process, and one county clerk even tried to talk a caller out of their abortion decision. This is what I see every day at the Florida Access Network. We take calls from people who need help getting to a clinic and paying for their abortions. We help people with rides or gas money to get to their appointments. We help coordinate their childcare. We help people with lodging when they have to travel long distances. And we help young people navigate the judicial bypass process. Since 2015, we've supported nearly 2,000 people, offering an average of $100 to help people meet the financial gap for their abortions, which cost on average $600 without insurance coverage. We fund abortion because low wages, abortion restrictions like SB 8, and policies like the Hyde Amendment make abortion unattainable. Without the communities of support we've created to relieve the burdens people face trying to access healthcare, no one should be turned away from healthcare that they want because they can't afford it. As I close, I want to remind the committee members of your responsibility to protect our right to have abortions free from undue burdens, shame, and stigma. You have the power to change the lives of millions of people in this country by enacting legislation that stands up for the dignity of every person who seeks an abortion. As we say at We Testify, everyone loves someone who has had an abortion, and that includes every single one of you. To the people listening who have had or will have abortions, you are supported, you are loved, and I will never stop fighting for you. Thank you for listening to my story, and I hope you remember that the actions you take impact your constituents and your loved ones who have had abortions. Thank you.
Thank you all for your testimony. We will now proceed under the 5-minute rule with questions. I will recognize myself for 5 minutes. Dr. Moyetti, how has SB 8 impacted abortion care in the communities you care for in Texas?
Thank you for that question, Representative. SB 8 has completely decimated abortion access in my state and in the communities that I take care of. I, every day almost, am getting calls from my colleagues in the Dallas-Fort Worth area asking how to take care of the patients that they serve. People with devastating pregnancy diagnoses, whether it's for the pregnancy itself or for them, unable to get care in our state, people with very severe chronic medical conditions with no other options, and just my neighbors, my colleagues and friends that have unintended pregnancies and have nowhere to turn to. We are working tirelessly to get people out of state, to help coordinate their care out of state, but it's a nightmare. I have never thought that medical care would come to this.
Ms. Pinheiro, SB 8 has had ripple effects across the country. Can you give us a brief overview of what it looks like for someone in Florida, especially someone who's struggling to make ends meet to seek an abortion? And if SB 8 is in Texas, remains in effect, what does this mean for Floridians and people in other states seeking abortions?
Abortion restrictions in Florida look like people like me on a Saturday morning sitting in my client's car babysitting her child because she didn't have access to childcare because she was busy working trying to support her family. You know, it's interesting hearing the committee talk about people's lives like they're so frivolous. Abortion restrictions impact people who are lied to by anti-abortion pregnancy centers about their gestational age. Abortion patients in clinics and providers are moving targets for harassment. And clinics are targeted by the state and forced to endure unnecessary regulatory restrictions in having an abortion. Thank you.
Thank you. Professor Bridges, during this hearing, I expect we will hear false claims comparing abortion to eugenics and our country's history of slavery. Can you share your perspective on those claims?
Absolutely. Thank you so much for that question. Those claims proceed from a misunderstanding of what eugenics was about. Eugenics was about state control of reproductive decisions. Eugenics was about the state deciding who could and could not become parents, who would and would not be a good parent. That's not at all what abortion is about today. Abortion is about people exacting a modicum of control over their lives. deciding to terminate a pregnancy because it is in their best interest. It is in the best interest of their children, meaning that many of the people who have abortions are already parents. And so the comparison to eugenics is not that abortion today is eugenics. In fact, abortion restrictions today are comparable to eugenics, in as much as abortion restrictions consist of the state determining what people will and will not do with their reproductive lives. It's the state deciding who will become a parent, even though those people do not desire to become a parent themselves. So again, the comparison is inapt. Abortion is not eugenics. Abortion restrictions are more akin to eugenics. Thank you.
Thank you very much, Ms. Fishbach.
Thank you, Mr. Chair. And I am just a bit curious what the purpose of today's hearing is. We're talking about a state law that is currently under review by the Supreme Court, and the Supreme Court will decide if the law is constitutional, and only the Supreme Court, not the House Judiciary Committee. That being said, we are here with a Texas state law in front of us. This law is currently in effect, and it is saving lives. It is saving the lives of unborn babies. Women and babies deserve better than being told that their only option is abortion. Many pro-life groups and individuals across the country reach out to pregnant women to help with support, with diapers, with housing, with love. Abortion does not help women. After saying that, I have a couple of questions for Ms. Foster. Ms. Foster, first of all, thank you for being here. I appreciate the time you took and sharing the information with us. In your experience, is it accurate to characterize elective abortion as healthcare?
It is not.
Thank you. Does that term accurately reflect what happens to a baby?
Healthcare?
Yep.
Absolutely not. Absolutely not.
And well, and maybe I should go back. Many of the members and witnesses present today have vigorously objected to the heartbeat law recently passed by Texas. The people of Texas chose, through their duly elected officials, to protect unborn babies at that point when a beating heart can be detected. How early can the fetal heartbeat be detected?
Frequently as early as 6 to 8 weeks. Yeah.
And are there any other things you can tell us about a baby that is going on at that gestational age?
Absolutely. At that point, you can see the beginnings of their arms, their hands, their legs, their feet, hearing the heartbeat, seeing the formation of their head and their features. We're talking about a human being. Life is not frivolous. That's the entire point here. And that child in the womb who is developing, who generally by the time that you hear that heartbeat, that child will be viable, that pregnancy will be viable. And so the chances that she or he will grow to full term are very good at that point.
And Ms. Foster, I wasn't necessarily going to do it, but I did bring along a 10-week model, and just to show that it's got you can't see it, but he's got fingers and toes and looks a lot like a little baby to me, and it saddens me when we cheapen life through abortion and just in general. But just one final question, Ms. Foster. You've written about providing alternatives to abortion, real alternatives, and it's necessary to really create a culture that allows for an understanding of motherhood and that is inclusive of women's hopes and dreams. Let's support women and not push them towards the violence and neglect of abortion. How can we as a nation better provide for women facing those unexpected pregnancies with real choices?
Yes, there are so many ways that we can really stand with women in need and partners in need and support them. That involves governmental methods and nonprofits that are actively working in communities throughout our nation, outnumbering abortion facilities in the hundreds. to thousands, and are providing real alternatives, are providing material resources like diapers, clothing, formula, car seats, you name it, that are providing things like career training, parenting training, and are just providing that hope and support, encouraging women that, of course, as we know, the primary three reasons why women seek abortion, whether we're talking about first trimester or late term from the abortion industry's own published studies, they're financial concerns, relationship issues, and not feeling ready to be a parent. All three of those areas are areas where we can come alongside women and stand with women and be there for them. And that is what pregnancy resource centers are doing in the thousands and communities throughout our nation. And that's what even we have government resources for. It's to stand with the disenfranchised and with the vulnerable and provide hope and support.
Thank you very much. And I would just say in closing, I think that would be a much better use of the committee's time to be looking at what we can do to help, instead of going through a law that is sitting in front of the Supreme Court, and they will make the determination of its constitutionality. Thank you, Mr. Chair. I yield back.
Gentlelady yields back. Ms. Jackson-Lee.
I thank the chairman very much, and I have the Constitution in my hand. I just want to quickly read the 9th Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny, disparage others retained by the people. We clarify and characterize that as a right to privacy, which has not been undermined. Professor Bridges, my time is short, so very carefully, is any law that you know dealing with abortion rights, Roe v. Wade and others, forcing women to get an abortion? Is this required? Are they hauled into physician's office? Or is this protection for their choice and their right to privacy? Professor Bridges?
Thank you for the question. No, no one's being coerced into an abortion.
And so today I want to focus on a legislation that I have that I'm very grateful that many members of the Judiciary Committee have decided to join, and we hope more will. The Preventing Vigilante Stalking that stops violence, stops women's access to health care and abortion rights. Again, H.R. 5710, Preventing Vigilante Stalking that stops women's access to health care and abortion rights. A new study by Dr. David Eisenberg, a board-certified obstetrician gynecologist, and I think this has an overall impact, estimates that Texas SB 8's new restrictions on women's health could cause increases in maternal mortality already high of up to 15% overall and up to 33% for Black women. Can you focus on the outright horror of what it means to have a private citizen, even if you don't know the particulars, a private citizen to have the capacity to stalk you and to receive money on your bounty in terms of the provider and or the woman? Dr. Moyedi?
Thank you so much for the question, Representative. I don't have to imagine what it's like to have violent people stalking me, because that is actually my life every single day as an abortion provider in Texas. I am followed into my job. I am screamed at. My child is screamed at by people that purport to love children. I get hate messages and death threats to my home simply for caring for my community. So it's very disturbing for me personally to hear people proclaim to be pro-life while they actively threaten my life and my child's life.
Would a federal
Yes,
law to prevent this kind of stalking at least give you a sense that the federal government understands how criminal that behavior is, even though it's a private citizen? Would a federal law prevent that?
Yeah, I'm not a politician, and so I don't really understand the ins and outs of a policy like that. I know that there are federal laws right now that should prevent these people from blocking access to our clinics and harassing our patients, but it does not. And so I welcome any opportunity to make our clinics more secure from violent protesters and to make my life safer from violent people. I'm just not sure what the right answer is.
Well, the stalking law is different. It stops people from stalking you under the federal stalking law. Would that help you?
I hope it would. I'm not sure. what I understand from stalking is that it has to be very persistent and routine. And so it is often very hard for us now, even to get the FBI or local police departments to care about the current harassment that we get.
I appreciate it. That would change. Professor Bridges, the same, as you well know, not since the fugitive slave law, we had this kind of independent bounty hunting going on. Very briefly, would a modification of the federal statute on stalking to stop people who are stalking you to prevent you to get health information or abortions, would that help? In the whole bill needs to be eliminated, but would that help overall?
I would have to see the text of the bill that addresses stalking in order for me to offer a formal opinion, and in order for me to determine whether it will in fact help. But I welcome any effort that will help people in Texas and people across this country exercise their constitutionally protected right to terminate a pregnancy before viability.
Thank you. Let me say to Stephanie, let me thank you for your courage, and you should not have faced what you faced. And I would simply raise the question, being in Florida as well, what do you think of a law that now is being promoted in other states that gives a private citizen, in addition to what you had to go to expose yourself in court, but a private citizen the right to stalk you and get a bounty? What does that do to your privacy?
It scares me. It scares the people that I support every day to get an abortion. I also welcome any legislation that would support with protecting clinic entrances. And I will say that, unfortunately, people break the law every day, right? So enacting a law that would criminalize this behavior would be great. It wouldn't eliminate stalking from happening.
The time of the gentlelady has expired. Mr. Shabbat.
Mr. Chairman, nearly
for your
50
answer.
years ago, the Supreme Court handed down one of its most controversial ever decisions, Roe v. Wade. Since that ruling, there have been over 60 million abortions in this country. 60 million innocent lives ended before they even had a chance. That's over 1 million abortions each year since this slaughter was legalized back in 1973 on January 22nd, which happens to be my birthday. Planned Parenthood alone performs over 320,000 abortions each year. That's approximately the population of my hometown, Cincinnati, Ohio. So Planned Parenthood essentially wipes out the equivalent of the population of Cincinnati every year, year after year. Mr. Chairman, life is precious, and we should do all we can to protect it. Since I was elected here, been involved in a whole range of pieces of legislation, introduced the ban on partial birth abortion, for example, which President Bush signed into law. It went all the way U.S. Supreme Court. They upheld it, and it's now the law of the land. But there are still far too many abortions in this country. The legislation that we're discussing today is Texas Law SB 8, and it would effectively, of course, ban abortions after a heartbeat is detected in the womb. This legislation has been described by many in the media as extreme and unprecedented. In reality, we've been discussing a ban on abortions after a heartbeat for years. In fact, 13 states, including my home state of Ohio, have enacted some form of legislation which prohibits abortions if a heartbeat is detected. And there's the Federal Heartbeat Protection Act, which Mike Kelly, a member of this institution, has co-sponsored, along with many of us, and a number on this committee. And so, Mr. Chairman, banning abortions after a baby's heartbeat is detected is neither extreme nor unprecedented. But I'll tell you something that is extreme, and that's allowing a massive abortion outfit like Planned Parenthood to kill the equivalent of Cincinnati's population every year. And something else that's extreme is witnessing members on the other side of the aisle abandoning the Hyde Amendment, which has enjoyed bipartisan support for 40 years now and has saved nearly 2.5 million lives. Getting rid of the Hyde Amendment will force American taxpayers to pay for other people's abortions. But even though the radical left is fully in control in the House and in the Senate and in the White House, states and local governments are fighting back. In addition to the heartbeat bills that we've already mentioned, earlier this year, 2 cities in my congressional district, Lebanon and Mason, became the first cities in Ohio to pass an ordinance making them pro-life sanctuary cities and forbidding abortions within their city limits. And I applaud the leaders in both of those communities for taking that brave stance, and I hope others will follow that example. Mr. Chairman, we need to be direct and honest about what's being discussed here today. Abortion is not health care. It's a barbaric procedure that ends the life of an unborn baby. By 10 weeks, an unborn baby has arms and legs and fingers and toes, and among other things, he or she can suck their thumb, stretch, jump when startled. In short, these babies are alive, and they deserve our protection. Ms. Glenn Foster, let me ask you this. One of our other witnesses has already quite astonishingly said that abortion is an act of love. Is that your opinion?
It is not. Life is not frivolous. Abortion is not health care. That's the whole point. And I never thought that I would hear an OBGYN tell this committee that dismembering a fellow human being is an act of love, an act of freedom. We can and we must do better.
Thank you. You mentioned the dismemberment abortion, and when we passed the Partial Birth Abortion Ban Act, we knew we were stopping thousands of abortions each year, but we knew there were other forms. Could you, and I know it's pretty horrific, but could you describe essentially what a dismemberment abortion is, which is still legal in this country?
Certainly. It involves inserting tools into the uterus, into the womb, to literally rip a child apart limb from limb. That's really the crux of it.
Pretty horrific stuff. And these babies oftentimes are capable of feeling pain. Is that correct?
Absolutely. If you're doing prenatal surgery, then not only do you provide anesthesia to the mother, you also treat the baby's potential pain.
And one last, I'm almost out of time. You know, we're trying to protect both the health of the woman and the baby. Is that right? We're trying to protect both.
Yes, and the majority of Americans understand that when we pass pro-life laws, that is what we are doing. We're protecting both mother and child.
Thank you very much. I yield back.
The gentleman yields back. Mr. Johnson.
Thank you, Mr. Chairman, and for holding this hearing. And Professor Bridges, let's start with the obvious. Texas's law known as SB 8 bans abortion at roughly 6 weeks of pregnancy. Isn't SB 8 a clear violation of the right to abortion prior to fetal viability, that right having been established under Roe versus Wade and reaffirmed in Planned Parenthood versus Casey, and most recently in 2018 in June Medical Services versus Russo?
Absolutely. In the words of Justice Sotomayor, SB 8 is flagrantly unconstitutional. Nevertheless, it is in effect.
So it would be fair to say that SB 8 is actually blatantly constitutional.
It's
blatantly unconstitutional.
Absolutely. Every superlative I have for you: blatantly, flagrantly, obviously, undeniably, all of them.
Well, Professor Bridges, what do you make of the United States Supreme Court's decision to allow the blatantly unconstitutional SB 8 to remain in effect while its constitutionality is challenged in the lower courts?
I take that to be a sign that the Supreme Court has backed away from its role as the apolitical branch of government. While the executive and the legislative branches are supposed to be the political branches, the judiciary is supposed to be the apolitical branch. Nevertheless, the Supreme Court is making decisions that reveal that it is being motivated by raw political will, raw political power.
Well, Professor Bridges, was it extraordinary for the Supreme Court, without full briefing, without oral argument, and without even the dignity of a reasoned opinion, to use its shadow docket to temporarily allow the state of Texas to deny a recognized constitutional right to nearly 1 out of every 10 women of reproductive age in this country?
Absolutely. It was extraordinary. It was egregious. It was extreme. Prior to September 1, very few people would have imagined that the Supreme Court would let a flagrantly unconstitutional law go into effect when it had the power to enjoin it.
And in fact, Professor Bridges, by allowing SB 8 to remain in effect during the pendency of the challenge to its constitutionality, the Supreme Court itself ignored stare decisis and denied every woman in the entire state of Texas a fundamental constitutional right. Isn't that correct?
That's correct. The Supreme Court backed away from its own established precedents, even regarding the shadow docket, which is to preserve the status quo. The Supreme Court allowed the status quo to change, and in allowing the status quo to change, it allowed for the infringement of the Texans' right to terminate a pregnancy before viability.
And you've touched on this, Professor Bridges. Does the Supreme Court's decision to allow SB 8 to remain in effect indicate how this ultra-conservative majority will approach future abortion cases?
Well, it sends the strongest signal I can imagine about how the Supreme Court feels about abortion rights, which are still fundamental rights under the U.S. Constitution. The Supreme Court's holding in Whole Woman's Health versus Jackson, its decision to let that flagrantly unconstitutional law go into effect, reveals that the Supreme Court does not care much for the abortion right, that it will not protect the abortion right in the same way that it will protect other rights that it favors.
Thank you, Professor. SB 8 is touted as protecting women when in fact it's doing nothing more than attempting to control, criminalize, and dehumanize women and their ability to exercise control over their reproductive health. Ms. Pinheiro, thank you for sharing your story here with us today. And based on your experiences, what substantive effects would the outcome that Professor Bridges just discussed have on individuals in your state?
People in the state of Florida are already facing restrictions to abortions. Florida has a 24-week gestational ban already in place, and any delay in abortion care it should be and remain unconstitutional.
Thank you. With that, I yield back.
The gentleman yields back. Mr. Gohmert.
Thank you, Mr. Chairman. Thank you to the witnesses for testifying today. Dr. Morietti, as I understood from your testimony, you've done late-term abortions, correct?
Sir, that's not a medical term, but I provide abortion care, yes.
Even past 22 weeks at times when it's allowed, right?
Depending on the jurisdiction in which I'm providing care, yes.
Yeah. We had some years back, some of y'all may remember, a person who had provided late-term abortion. And it is interesting that, in the medical field, there are terms, in the legal field, there are terms. But he described in detail, I think he said he'd done over 1,000 late-term abortions, or if you'd prefer, dismemberment abortions. And he described in much greater detail, Ms. Foster, about the instrument that was used to insert into the womb. And he described how he would feel around for something linear. And the longer linear he knew was a leg, he would clamp on. And he described in detail how he would pull that leg out of socket and pull it from the body. And then how he would then find another linear object about the same length, rip that off of the body, and then feel around for two shorter linear items, knowing those were the two arms, rip them out from the body. And once they were removed, he said, in his words, it would feel for something bulbous. And you knew that was the skull. And you would clamp onto the skull and crush it, because the child's head would not come through the uterus with that was at that point not dilated. And then it would be easier once you had crushed the skull, yanked it away from the body, to then pull the body out. For some of us, that is considered, and I know Dr. Moyetti used the term hateful and cruel with regard to the Texas law, but some of us would describe that procedure of ripping arms and legs and the head off of a baby as being a bit hateful and cruel. We've also heard that reference to your position being somewhat hateful and cruel. Ms. Foster, do you disagree that mothers who are carrying a child that they didn't expect or did not want deserve to be loved?
Of course, absolutely.
Have you provided help to mothers in that condition?
I have in a variety of ways. First of all, I was myself in that position when I was 19 years old. I needed that help and love. I did not find it. So I've spent the years since trying to be that hope and help and love to other women and other families. I served as chair of the board of a pregnancy center for a number of years. I still continue to serve on that board. I have volunteered with numerous other pregnancy centers. I have sidewalk counseled. I have reached out to women and families in my community and simply served as a safe space and a sounding board and a resource so that when people found themselves in an unexpected situation, they would be able to find out more and get information about where to go.
Thank you. And Dr. Moyetti, when you've done abortions, is there another physician there, or are you the only medical doctor involved in the abortion?
I'm a doctor of osteopathic medicine, and depending on where I provide abortion care, there might be another physician in the room or not.
Yeah. I was just curious because when my wife's and my first daughter, she's amazing. When she was born very prematurely, we had the OB-GYN, and we also had a pediatrician there whose sole goal and job was to protect the entrance of our child. And he did an amazing job. It required hospitalization and intubation, all kinds of things. But I'm so thankful we had a pediatrician there looking out for the interests of the child and an OB-GYN looking for the mother. I commend that to everyone else. I yield back.
The gentleman yields back. Ms. Bass? Ms. Bass, you should unmute yourself.
I'm so sorry. Sorry about that. Thank you, Mr. Chairman, for conducting this important hearing and to the witnesses for your testimony here today. It's not lost on me that we are here discussing a bill that empowers essentially vigilantes to circumvent the rights of others. And I really wanted to ask one of the witnesses, Professor Bridges, if you could talk about that aspect of the bill, and then also put it in its historical context in terms of that type of policing and the impact that that's going to have and how you imagine that's going to play out in the state of Texas.
Yeah. Thank you so much for that question. So what, and the term that you use, vigilante justice, is precisely what I would use to describe what's going on in Texas. Essentially, the state is allowing, the Supreme Court has allowed the state to allow private citizens to police, to terrorize, to control the bodies of other private citizens. That is precisely how we would describe chattel slavery in this country, for example. The state was permitted to allow private citizens to police, terrorize, control the bodies of the other human beings who they considered to be property. I will also note that the analogy is not inapposite at all, because part and parcel of chattel slavery was the control of people's reproductive lives. It was because humans were property. It was an incentive of the people who purported to own that property to coerce the birth of more property. And so the state allowed private citizens to coerce birth from people. That's precisely what's happening in Texas.
Well, but let me just ask you, because that doesn't apply to everyone.
Mm-hmm.
I don't think it applied to everyone back in the days of enslavement. And I don't know if the vigilantism that is okay in this bill applies to everyone either. I mean, for example, I don't know to the extent that that would apply to a woman who is particularly affluent.
Oh.
I don't exactly know, and maybe you can describe a little bit about that. I also think it's kind of ironic because right now they just finished picking the jury in the Ahmaud Arbery trial. And that was, to me, exactly that type of vigilantism. The young man was jogging, and he was essentially gunned down because they assumed that he had done something wrong. So how does it even work in the bill? I mean, how is somebody supposed to know the woman in that car is where she's going?
Right. You just got to guess. And the thing is that the bill incentivizes people to guess, to attempt to reap the monetary rewards of a successful lawsuit. One thing that I just want to mention, thank you for bringing up Ahmaud Arbery. It's such a tragedy, but at least his family has the ability to try to seek justice in the courts. What the Supreme Court has done up until right now, we're still in a world in which the Supreme Court has boxed individuals out of the federal judiciary. There's nowhere where we can seek recourse. And so that is why Congress has to act.
Well, I wanted to know also if you could talk about maybe other aspects of this history in the criminal justice system. I mean, you mentioned the period of enslavement. But I want to know if you could describe other times, and if you could also speak about how abortion bans and restrictions are already used to criminalize people accessing abortion, and how it could get worse if Roe is overturned.
Right. I mean, so I spoke about chattel slavery, but we know that history extends well beyond chattel slavery throughout Reconstruction. It took a civil rights movement before people of color were granted formal citizenship. And so private actors were permitted to control their lives. I want to spend some time, though, talking about how bans and regulations like SB 8 move abortion access out of the hands of the most marginalized people. And what that means is so those with privilege, as you gestured to before, are able to travel to Kansas, they're able to travel to Oklahoma, they're able to travel to my state of California. They are exercising their constitutional rights, albeit burdened. The most marginalized are unable to do that. And what that means is that they're resorting to methods that have been criminalized, especially in Texas.
Well, I actually wonder whether an affluent woman would have to leave the state, because I would imagine that a woman of affluence could have that type of care right there in the state of Texas.
Absolutely. We know that in pre-Roe era, people were able to get abortion from their obstetricians.
All right. Thank you. I'm out of town.
Thank you.
Thank you.
The gentlelady yields back. Mr. Issa.
Thank you, Mr. Chairman. Professor Bridges, you're familiar with a great deal of constitutional law. Would you say that the decisions decided by the Supreme Court against President Trump were appropriate in deciding the questions of the election?
I am a constitutional law scholar, but I do not do my expertise is not in election law.
I understand, but you were you're at UC Berkeley, you're a professor. You did note those decisions, didn't you? Did you think that they were reasoned? Did you have any objections to them?
I could speak about how I felt about them from a layperson's perspective, but because I'm not an election law scholar, I can't speak on the well-reasoned nature or not of those decisions.
Thank you. Ms. Foster, do you find it interesting that everyone seems to have an opinion that the Supreme Court is extreme and biased when it comes to one issue, but this would be no exception. Anytime the court seems to rule against what conservatives would like, I hear nothing but that they're well-reasoned and balanced. Do you find that humorous, even from your position, not as a scholar in that area?
It certainly is interesting. As we heard earlier, Chuck Schumer stood on the steps of the Supreme Court on March 4th, 2020, and threatened Justices Gorsuch and Kavanaugh, prompting a rare public response from the Chief Justice, who called the remarks inappropriate and dangerous. We see these transparent efforts to bully the Supreme Court into issuing opinions that serve certain policy goals rather than interpreting the Constitution. And I believe we should all be raising our sights. We know that too much of life in Washington can feel like political theater. Today need not be that way. We can all care about women here today, and we do, but true care must start with the stopping of abortion.
And to that extent, it is interesting to me that the Associated Press and the University of Chicago found that 65% Americans said abortion during the second trimester was wrong, and 80% in the third trimester. It's interesting that more than half of the witnesses and more than half of the people here on this dais have the exact opposite opinion as 80% of Americans, including, President Biden, who, unlike the chairman, has expressed skepticism in court packing as a solution. I want to play something for the record here very quickly.
Should be of an America where abortion is safe and legal, but rare.
Did you hear anything today from the majority that implied that they agreed with President Clinton on the rare part of abortion?
It seems like today the focus is on making abortion legal and ubiquitous, but certainly not rare, and as we all too often see, not safe. We need a court that is concerned with justice.
Well, and speaking of justice, look, I'm from a state where even trying to provide abortion alternatives, even making young pregnant women in need aware of families who would adopt their child and give them a good home is discouraged and sometimes prohibited. So I'm not from a state that is like Texas. But looking at Texas and Florida for a moment, did Texas and Florida, for example, at 22 weeks, is it consistent with the Roe decision? Is Florida, in that part of its law, looking at viability and setting a number which is certainly viable with today's science?
Absolutely. Florida's law regarding late-term abortions is completely in line with the Constitution, is completely in line with viability and the limits set by Roe v. Wade and Planned Parenthood v. Casey, and it is in line with the opinion of the vast majority of Americans, including Democrats and self-described pro-choice Americans.
So today we're hearing something that is inconsistent with 80% of Americans. We're hearing testimony, except for yours, that implies extreme by a court that has been well balanced, and we're hearing that somehow it's extreme to set 22 weeks, a point at which babies are regularly born alive and well, is somehow wrong. Isn't that what we're hearing here today?
That is what we're hearing, and there is nothing more tragic than abortion killing when a child can already definitively survive. There is no medical basis for killing a child at 22 weeks or later. Absolutely none, and you don't need to be a doctor to make that decision or judgment. You simply need to be a human being.
Thank you, Mr. Chairman. I rest my case.
The gentleman's time has expired. There are a series of votes that have started on the floor, so the committee will be in. You think we can do one more? Okay, we'll do one more. Mr. Jeffries.
Thank you very much, Mr. Chairman, for convening this incredibly important hearing. Ms. Foster, the Texas law doesn't start at 22 weeks. Is that correct in terms of its restriction?
That is correct.
It starts at 6 weeks. Is that true?
It does.
Okay, so I'm not really certain what the prior conversation was about.
Would the gentleman yield?
No, I won't. If under the Texas abortion ban, someone who misses that 6-week window would be forced to carry their pregnancy to term, even if they were raped. Is that correct?
Under the Texas law, that the protections for the mother and for the child start with that detection of the heartbeat at 6 weeks. Yes.
Right. So there is no exception beyond the 6-week period for rape, correct?
You know, when we're talking about rape, it is a horrible tragedy, period. There are no ifs, ands, or buts about that, and we need to rid the world of those kinds of actions. But nowhere in our justice system is there ever a time when the innocent has to pay for the crime of another, for the crime of the father. The killing of a baby for the crimes of his or her father is never justice. In fact, that's injustice.
All right. The question is there a rape exception? The answer is no. And the question that's interesting, because you were talking with my former colleagues about public sentiment, is the absence of a rape exception popular amongst the American people or even the people in the great state of Texas?
Yes, 55% of Texans support the heartbeat law, let alone something as far along as 22 weeks. So yes, most Americans and most Texans do support this heartbeat law.
Yeah, that's very inconsistent, and that wasn't an answer to the question that I asked. Let's go to another particular issue. If someone misses this 6-week window and the pregnancy resulted from incest, would they still be forced to carry that baby to term?
Again, I would simply say the child does not deserve the death penalty for the father's crime. And so the heartbeat bill is protecting children from the moment that that heartbeat is detected.
Right, so there's no incest exception in the Texas so-called statute. Is that correct?
Wouldn't that fall under rape as well?
It's a yes or no question.
Correct.
Is there an incest exception? Yes or no?
There is no specific incest exception, but the child does not deserve to die because of the crime of a father.
Okay, Professor Bridges, let me ask you a question, picking up on a theme that my colleague Karen Bass was pursuing with you in terms of criminalization. And would the outlawing of abortion and restricting the reproductive freedom of women, as is being done in a very extreme and draconian way in Texas, would that have a disproportionately adverse impact on Black women?
Absolutely. And this is true for a number of reasons. One, Black people disproportionately bear the burdens of poverty. So that means, two, that they have higher rates of unintended pregnancy, which is the main reason why people choose to exercise their constitutional right to terminate a pregnancy. Moreover, if they do not have the right to legally terminate a pregnancy, that means that people will resort to things that have been criminalized. We know, just look across the country, that even though we have race-neutral criminal statutes that are supposed to apply to everyone equally, people of color are those who are disproportionately arrested, indicted, convicted, incarcerated under our criminal laws. And so any criminal law we can expect to have a disproportionate impact on people of color.
Well, thank you very much. And just in closing, I know my colleague talked about the issues in terms of the Supreme Court. I respect all of my colleagues on both sides of the aisle as we debate and discuss all of these issues. But part of the challenge that many of us have with this current extreme right-wing Supreme Court is that, engineered by Mitch McConnell, he stole not one, but two Supreme Court justices. One from President Obama and the other from President Biden, explicitly to jam these types of
gentleman's time has expired
down the throats of the American people. Thank you very much, and I yield back. Mr. Chairman, Jerry Nadler.
The gentleman yields back. A series of votes have been called on the House floor Therefore, the committee will take a recess and will return immediately after the conclusion of these votes. The committee stands in recess.
Looks fancy. Fancy salads and shit like that. No, just the treatment's done. It's just recovered now. As long as it's all well worked out. Yeah, oh yeah. Yeah. I think him and I are Is it more humane to disassemble violently by my cat? Because that was the ultimate. Doesn't kill him, just it repels him.